Okay, so we're going to talk about the case of GUERRERO'S Transport Incorporated versus BTEA Kilusan et al. GR number L-41518 June 30, 1976. Okay, so this is a case between Blade Black Transportation Services Employees Association Kilusan, Labor Arbiter Francisco M. De Los Reyes, and Jose Cruz, respondents. So this is penned by Antonio J. Certiorari and prohibition with preliminary injunction to annul the orders of the National Labor Relations Commission on March 26, June 20, and September 25, 1975, as well as the writ of execution of September 26, 1975, issued in NLRC case number 214, and to restrain respondent Deputy Sheriff of Manila from implementing said writ. So on June 1, 1972, the United States Naval Base authorities at Subic, Zambales conducted a public bidding for a 5-year contract for the right to operate or manage the transportation services inside the naval base. This bidding was won by Santiago Guerrero, the owner or operator of the GUERRERO'S Transport Services Incorporated. Herein, petitioner over Concepcion F. Blaylock, and then the incumbent concessionaire doing business under the name of Blaylock Transport Services, whose 395 employees are members of the responded union BTEAKILUSAN. So these are the union members of the other bidder for this service. So when petitioner, after the commencement of its operation on January 1, 1973, they refused to employ the members of the respondent union and latter. So I think the losing bidder has a group of employees that they wanted to absorb on the next winning bidder, which is now the business of Guerrero, the owner and operator of GUERRERO'S Transport Services. On January 12, 1975, filed a complaint with the National Labor Relations Commission, docketed as NLRC case number 214, against GUERRERO'S Transport Services Incorporated and Santiago Guerrero to compel them to employ its members pursuant to Article 1, Section 2 of the RP-US Base Agreement dated May 27, 1968. This case was dismissed by the National Labor Relations Commission on March 13, 1973, upon petitioner's motion to dismiss on jurisdictional grounds, there being no employer-employee relationship between the parties. Okay, so the respondent union then appealed order on March 26, 1973 to the Secretary of the Department of Labor, who, instead of deciding the appeal, remanded the case to review to the NLRC, which subsequently summoned both parties to a series of conferences. So when it was appealed to the higher court, the NLRC dismissed it, but when it was appealed under the Secretary of Labor, instead of deciding on the appeal, the case was remanded to review to the NLRC. It went back to the NLRC, which subsequently summoned both parties to a series of conferences. Thereafter, on October 11, 1973, the NLRC issued a resolution ordering the petitioner, among others, to absorb all the complaints who filed their applications on or before the deadline set by the petitioner on November 15, 1972, except those who may have derogatory records with the U.S. travel authorities in Subic, Zambales, and directing the officer in charge of the Provincial Office of the Department of Labor in Olongapo City to oversee the preparation of the list of those qualified for absorption in accordance with this resolution. So what did the petitioner do? So the petitioner appealed to the Secretary of Labor, Blas F. Ople. The petitioner here, remember, is GUERRERO Transport Services. Rendered a decision. He again appealed to the Secretary of Labor in the name of Ople. In turn, there was a decision on December 27, 1973, affirming the said resolution. Okay, so it was affirmed. In January 22, 1974, Guerrero appealed the decision to the President of the Philippines, but on July 9, 1974, the President, through Assistant Executive Secretary Ronaldo B. Zamora, returned the case to the Secretary of Labor for appropriate action on the appeal, it appearing that the same does not involve national interest. In the meantime, the Provincial Director of the Labor Office in Zambales furnished on August 2, 1974, petitioner a list of 46 members of respondent union BTEAKILUSAN and former drivers of Blade Black Transport Service who are within the coverage of the decision of the Secretary of Labor in requesting petitioner to report in its action on the matter directly to the chairman of the NLRC Manila. Subsequently, Santiago A. Guerrero received a letter dated September 24, 1974 from Colonel Levi L. Basilia, PCGSC Camp Oliva, San Fernando, Pampanga, requesting compliance with the order dated July 19, 1974 of the NLRC case. In his reply, a letter dated October 4, 1974, Guerrero informed Colonel Basilia that he had substantially complied with the decision of the Secretary of Labor affirming the NLRC resolution in October 31, 1974 in the NLRC case, that any apparent or non-compliance therewith was attributable to the individual complainants who failed to submit themselves for processing and examination as requested by the authorities of the U.S. Naval Base in Subic, preparatory to their absorption by petitioner. On January 18, 1975, Acting Secretary Roberto V. Reyes, pursuant to Section 10 of Presidential Decree No. 21, directed the Chief of Constabulary to arrest the executive officers and petitioners. On February 20, 1975, petitioner informed Secretary Reyes that it has substantially complied with the NLRC resolution October 31, 1975, as out of those listed by the Regional Labor Director, only a few passed the examination given, and some of those who passed failed to comply with the final requirements of the U.S. Naval Base Authority, and that only those who passed and complied with the requirements of the U.S. Naval Base Authority were extended appointments as early as December 16, 1974. But none of them, for evident lack of interest, has reported for work. In his first endorsement dated March 26, 1975, Secretary Zamora required the Secretary of Labor to verify petitioners filed by respondent union, issued an order stating that upon the finality thereof and by the way of implementing any writ of execution that may be used in this case, further hearings shall be held to determine the members of the respondent union who are entitled to reinstatement in accordance with the basic guidelines finally determined in this case. On June 20, 1975, Respondent Labor Arbiter de las Reyes ordered the reinstatement of 129 individuals to their former or substantially equivalent positions without loss of seniority in other rights and privileges. On July 16, 1975, the union filed a motion for issuance of writ of execution with Respondent Labor Arbiter, but this was objected by petitioner, contending that Labor Arbiter has no jurisdiction over NLRC case number 214, and therefore his proceedings and orders resulting therefrom are null and void. On September 1, 1975, the Provincial Director of Zambales Labor Office, pursuant to the directive of the Secretary of Labor and NLRC resolution dated October 21, 1975, submitted a detailed information to the Assistant Secretary of the Department of Labor on petitioner's compliance to enable the Department of Labor to formally close the case. On September 25, 1975, Respondent Labor Arbiter, acting in the motion for execution filed by the Respondent Union, BTEAKILUSAN, finding that both orders dated March 26 and June 20, 1975 have not been appealed pursuant to Article 223 of the Labor Code, declared said orders final and executory, and directed petitioner Guerrero Transport Services Incorporated to reinstate the 129 complainants and to pay them the amount of 4,290 each and a total of 592,110 as back wages covering the period from August 22, 1974 to September 20, 1975. On September 26, 1975, Respondent Labor Arbiter issued a writ directing the Respondent Deputy Sheriff of Manila levy on monies and or properties of petitioner, and on the same date, Respondent Sheriff immediately served said writ on petitioner, who was given a period of 5 days within which to comply therewith. It was on this factual environment that the petitioner instituted the present petition for certiorari and prohibition with preliminary injunction on October 6, 1975. Petitioner asserts that the aforementioned orders were issued by the Respondent Labor Arbiter without jurisdiction. As prayed by this court, October 6, 1975 issued a temporary restraining order and required that the respondents file an answer within 10 days from notice. So here, on October 11, 1975, respondent labor arbiter De Los Reyes and Sheriff Jose Cruz filed their comment by way of answer to the petition explaining the legal justifications of their action and the premises. Upon motion filed on October 11, 1975, respondent union for consideration and to lift the temporary restraining order on October 6, 1975, this court on October 15, 1975, lifted the said restraining order and set a case for hearing on Monday, October 20, 1975 at 3 p.m. At the hearing of this case, October 20, 1975, a compromise agreement was arrived at the parties and wherein they agreed to submit to the Office of the Secretary of Labor the determination of the members of the respondent union who shall be reinstated and absorbed by the herein petitioner in transportation service inside the naval base, which determination shall be considered final. The court approved this agreement and enjoined all the parties to strictly observe the terms thereof. This agreement is deemed to have superseded the resolution on National Labor Relations Commission on October 31, 1973, as affirmed by the Secretary of Labor on December 27. So it supersedes their previous compromise agreement. Pursuant to this agreement, this was embodied in resolution of this court on October 24, 1975, that the Secretary Labor of Blas Ople issued an order dated November 13, 1975, the pertinent portion which reads as follows: the issue submitted for resolution hinges on the credibility of alleged applications. Considering that the employees are economically dependent on their jobs, they have all the reason and zealousness to pursue their jobs with the legitimate framework of our laws. The applicant are no strangers to the pains and difficulties of unemployment. Because these factors, we cannot ignore the affidavits of proof presented by the employees concerned as against the declaration of the herein respondent. Firmly entrenched is the rule in this jurisdiction that doubts arising from labor disputes must be construed and interpreted in favor of the workers. So, responsive to the foregoing, the National Labor Relations Commission through Arbiter Francisco de los Reyes is hereby directed to implement the absorption of the 175 members of the Blaylock Transport Employees Association or the BTEAKILUSAN into the Guerrero Transport Services subject to the following terms and conditions. Now, these are the conditions written here. They are bona fide employees of Blaylock Transportation at the time the concession expired, and that the appellant shall pass final screening and approval by the appropriate authorities of the U.S. base concerned, and the applicants to be processed for absorption shall be those in the list of 46 submitted by OIC Liberator Carino on August 1974, and a list of 129 determined by Arbiter de los Reyes as embodied in the writ of execution issued on September 25, 1975. So the Regional Director of Regional Office Number 11, Number 2, San Fernando, Pampanga, shall make available to the parties the facilities of that office in the implementation of the aforesaid absorption process. So there is, number 1, they should be bona fide employees. Number 2, they shall pass final screening and approval by the appropriate authorities on the U.S. base. So in November 24, 1975, in compliance with the aforesaid directive of the Secretary of Labor, Labor Arbiter Francisco M. de los Reyes conducted a hearing to receive evidence as who are the bona fide employees of the former concessionaire at the time of its concession expired. Thereafter, Labor Arbiter de los Reyes issued an order dated November 25, 1975, listing in Annex A thereof 174 employees who are bona fide employees of the private respondent, and transmitting a copy of said order to the base commander, the U.S. Naval Base Olongapo City, with the request of the immediate screening and approval of their applications in accordance with the applicable rules of said command. The pertinent portion of said order reads as follows: as far as this labor arbiter is concerned, his only participation in this case refers to the portion of the Secretary's Labor directing him to implement the absorption of 174 members of the union into the Guerrero Transport Services subject to the certain terms and conditions. Hence, any question of prematurity as espoused by the respondent counsel may not be entertained by the labor arbiter. Now, going now to the applicants who should be entitled to absorption, the Secretary of Labor specified that the same should not be composed of the 46 submitted by OIC Liberator Carino on August 2, 1974, and the 129 applicants determined by the labor arbiter. Of the latter, only 128 will be named. A perusal of the said list showed that the same Renato Cariaga has been doubly listed. For convenience, these two listings have now been consolidated and alphabetically arranged, and as an integral part of this order has been made as Annex A. For purposes of implementation, the initial step to be undertaken is for the submission of the name of the applicants to the U.S. Navy authorities concerned, which means that the U.S. Naval Base of Olongapo City for screening and approval of appropriate authorities. Regarding the determination of whether the applicants are bona fide employees of Blaylock Transportation at the time of its concession expired, the parties appear to be in agreement that the records of this case will eventually show whether applicants are such employees. Further, we feel that such employment will likewise appear in the records of the U.S. Naval Base at Olongapo City, since persons connected with the base, like the applicants, have to undergo processing of naval authority. Wherefore, in view of the foregoing considerations, copies of this order with Annex A hereof are hereby transmitted to the base commander of the U.S. Naval Base Olongapo City with a request for immediate screening and approval of the said applicants in accordance with the applicable rules of that command. So, pursuant to Section 6, Article 1 of the Philippine-U.S. Labor Agreement May 27, 1968, the United States Armed Forces undertook, consistent with military requirements, to provide security for employment. And in the event of certain services are contracted out, the United States Armed Forces shall require the contractor or concessionaire to give priority to consideration to affected employees for employment. A treaty has two aspects: as an international agreement between states and as municipal law for people of each state to observe. As part of municipal law, the aforesaid provision of this treaty enters into and forms part of the contract between petitioner and the U.S. Naval Base authorities. In view of the stipulation, the new contractor is therefore bound to give priority to the employment of qualified employees of the previous contractor. It is obviously in recognition of such obligation that petitioner entered into the aforementioned compromise agreement. As above indicated, under the compromise agreement as embodied in the resolution of the court dated October 24, the parties agreed to submit to the Secretary of Labor the determination of as to who of the members of the respondents union shall be absorbed or employed by the herein GUERRERO'S Transport Incorporated, and that such determination shall be considered as final. In connection therewith, the Secretary of Labor has issued order November 13, 1975, directing the NLRC through the labor arbiter Francisco de los Reyes to implement the absorption of 175 members into the GUERRERO'S Transport Services, subject to the following conditions: that they are, number one, bona fide employees of Blaylock Transport Service Incorporated at the time of the concession expired, and number two, that they should pass final screening and approval by the appropriate authorities of the U.S. Naval Base concerned. According to the private respondent, however, Commander Vert Plate C of the U.S. Navy Exchange declined to implement the order of the labor arbiter, as it is the petitioner who should request for screening and approval of the applicants. Considering that the aforementioned compromise and agreement of the parties as approved of this court is more than a mere contract and has the force and effect of another judgment, it is therefore conclusive upon the parties and their privies. For it is settled that a compromise has upon the parties the effect and authority of a res judicata, and is enforceable by execution upon approval by the court. Since the resolution of the NLRC on October 31, 1973 required the absorption of the applicant subject to the conditions therein contained, and there being no showing that such conditions were complied with, the labor arbiter exceeded his authority in awarding back wages to the 129 complainants. So there was supposedly no awarding of back wages because it was not embodied in the previous compromise agreement or the latest compromise agreement. Accordingly, judgment is hereby rendered ordering petitioner to employ members of Respondent Labor Union Kilusan, referred in the order of Secretary of Labor November 13, 1975, who satisfy the criteria enunciated, and those who were bona fide employees of Blaylock Transport at the time its concession expired, and those who passed the final screening and approval by the appropriate authorities of the U.S. Naval Base. For this purpose, petitioner is hereby ordered to submit and to secure from the appropriate authorities of the U.S. Naval Base Subic Zambales the requisite of screening and approval and the names of aforementioned members of Respondent Union. The order, dated September 25, 1975, Respondent labor arbitrator Francisco de los Reyes awarding back wages to the 129 complainants in the total of 592,110 pesos is hereby set aside. No pronouncement as to cause. But I think here in the separate opinions, no, the opinion of the court penned by Justice Antonio is, in his usual comprehensive and lucid manner, manifests fealty to the mandates of law. It is entitled to full concurrence. The parties duly represented by the council entered into compromise in terms are thus binding into them. They should be adhered to. Accordingly, there must be compliance with what was ordained by the Secretary of Labor in his order November 30, 1975. So, it has been decided by us. We have no choice in the matter. Unfortunately, the respondent labor union, no provision was made for back pay. That was an omission that ought to have been remedied before the compromise was entered into. This court, however, is sympathetic. Now, it may be to the claims of labor can go farther and that was assented by the parties themselves, so the law prescribes. Nonetheless, the writer is impelled to write this brief concurrence because of his belief that while the court is precluded from granting additional relief to the members of respondent labor union, in the meanwhile had been laid off, still their situation is not necessarily devoid of any hope for improvement. The present labor code stresses administrative rather than judicial regress. It has the advantage of greater flexibility, or more discretion on the part of the Secretary of Labor that could be utilized on their behalf. Certainly, from what appears on the record, the course of conduct pursued by the petitioner left much to be desired, not only from their standpoint. It yields the impression to me, at least, that there was no fidelity to the basic policy of labor as prescribed by the present Constitution. Petitioner commenced its operation on January 1, 1973. It refused to employ the members of respondent union, prompting the latter to file a complaint with the NLRC against it, and one Santiago Guerrero to compel them to employ its members pursuant to Article 1, Section 2 of the Republic of the Philippines U.S. Basis Agreement. 5 days thereafter, on January 17, 1973, the present Constitution came into effect. And time again, this court has correctly stressed how far the present Constitution has gone in seeing to it that the welfare of the economically underprivileged receive full attention. All that has to be done is to refer to the expanded scope of social justice and the specific guarantees intended to vitalize the rights of labor. The security of tenure is one of the basic features. Had the provision been lived up to the members of the respondent labor union would not be in the sad plight as they are in at present. It is to be admitted that complicated matters is that the service to be rendered is inside the U.S. naval base of Olongapo. Accordingly, the intervention of authorities therein cannot be avoided. That is quite understandable. At the same time, in line with what is held in Regan versus Commissioner Internal Revenue and People versus Gozo, the jurisdiction vested in this government over every inch of soil of its territory compels the conclusion that its laws are operative even inside the military base or naval reservation, except as limited by the military base agreement. Moreover, the interpretation of such provision must be most restrictive to ensure that there be at least the least derogation of the rights of territorial sovereign. The thought cannot be entertained that the naval authorities concerned would be insensible to the fundamental public policy of according to the utmost consideration to the claims of labor. This observation is made with the hope that if paid attention to respondent labor union through the efforts of administrative officials could still reasonably hope that the financial burden long sustained by its members could be eased, all in accordance with law. So that's the case of Guerrero Transport. Again, reflection for the concurring opinion. We see the emphasis of the expanded definition of social justice, and we are hoping, the Fernando J, in his concurrence, is hoping that even if the agreement between the parties were binding, we should have taken into consideration the claims of labor and to take into consideration the principles of social justice, because these people are deprived of their right, and supposedly it should have been expanded to ensure that these people will receive that so-called balance and equity when it comes to labor.